Afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. So while your questions are coming in, I have a great topic for you today. Hello. Thanks so much for the love on Instagram. I appreciate it. Now, my advice is go ahead, start putting your questions in the comments now, because as soon as I'm finished talking about the topic that I'm here to talk about, I'm going to jump straight into questions. Now, I am going to be talking about whether you should be filing or continue with the filing of a marriage based green card, or should you move forward with a VAWA filing. Now, remember that, of course, marriage green card is where you're applying to get permanent residence through either your US citizen or legal permanent resident spouse, parent, or child. And then there's a VAWA process. If you're being mistreated by that petitioner, so that spouse, the parent, or the child, and when I say child, I mean a US citizen child who's age 21 and up, you could have the option to apply for VAWA. Now, I often hear this. One of my rules here is apply early for VAWA. Oftentimes, I'll consult with someone who's going through the process already. They're going through the marriage-based process usually, even though it's open to the parent-child type of filing. And they will often say this. Well, let's see. Hi there, Lucky876. It's nice to see you. I hope your day is going good too. It's nice to see you. Um, so you'll see the person will say, well, let's see how it goes. I'll see how it goes. I'll stick it out with this person that's mistreating them. And then maybe if things really go bad, they'll consider applying for VAWA. But here's the problem with that reasoning. And it's, of course, they've not filed for VAWA, so they don't know what it's about. They're intimidated by the process, and they think they have to stick it out with a U.S. citizen spouse to get the green card. Otherwise, it's going to get a lot harder for them. But here's the problem with that reasoning. If they are going through the process, if they're consulting with me and they're having a problem with going through the green card process with their spouse already, that spouse is likely not going to allow them to get the green card. That's the part that I see in my experience that person can't really predict. But I've seen it enough times to know that whenever a spouse, a US citizen or a legal permanent resident spouse, they're dragging their feet, they're using the immigration process against you, they're going to cancel it, they're on and off about they're going to cancel the filing, they're going to send you home. They're playing this game with you, and eventually they are going to go ahead and sabotage your process. So they're either going to show up to the interview and they're going to intentionally make it look as if this is a fake marriage, that they don't know anything about you, they're not going to answer questions correctly, or they're not going to show up at the interview. And so the officer is not going to ask, is this person mistreating you? Even if they ask, that officer is not going to make any moves to help you. It's very likely they're not even going to advise you about VAWA. So you go into that interview without your spouse, that officer is going to deny your application because they're going to believe this marriage isn't bona fide. The spouse didn't even show up. Or they're going to, somewhere along the process, they're going to go ahead and withdraw the application. And usually when they withdraw that application, they do it in secret. So you'll just get a letter saying your adjustment of status application, your work is terminated. You have 33 days to leave the country, and any benefits you received along with the I-485, the adjustment of status, such as your work permit and your travel document, are now null and void, or they'll be null and void within that period. So you don't want to risk that. If your instincts, if your gut is telling you that your spouse is you they're not trustworthy, they're not dependable, they're playing games with you, it's time to apply for VAWA, right? Now with VAWA, if you're being mistreated verbally, mentally, emotionally, financially, you could qualify for this. I just recently got an approval based on financial abuse, only on financial abuse, right? So it does qualify. So if your spouse, for example, is using you as their cash cow, if they're blackmailing you for more and more money, they won't go through the process unless you give them money. They'll deport you if you unless you give them money. Then it's time to apply for VAWA. Don't wait, because if you wait, your case is going to get a lot more complicated. So for instance, say you wait until they don't show up to the interview, you wait until they withdraw your application, or you wait until they go ahead and they go to the interview, but they sabotage it. Now immigration has on record that this spouse had a say. They had a say before you had a say. They either wrote a letter, they gave an impression at the interview, or they went ahead and when they wrote that letter, they withdrew the application or they didn't show up. That says a lot too. And so they already have on their record that this is not a real marriage, right? The last thing they're thinking about is mistreatment. They're just focused on then denying it, because there's no way a spouse in a bona fide marriage is going to do withdraw an application or not show up to the interview or go to the interview and pretend as if they don't know anything about you. Now, at that point, you come back to me and you say, okay, I got denied. I'm ready to apply for VAWA. Now we have additional hurdles to jump over, because they already have on file that you lacked proof that your marriage was bona fide. Now we have to up the game to be able to show your marriage was bona fide and that you experienced mistreatment. And then of course, eh, they can consider this, information in the application to see, is this fraud or is this really a VAWA case, right? Because now your spouse in one way or the other has a say. When you apply for VAWA, you beat the spouse to any kind of sabotaging of your process, and they call in after you filed for VAWA. Unless the evidence that the spouse provides, the spouse can corroborate the evidence, they can't use it against you in the VAWA process. So say, for example, the spouse threatened to report you to ICE and threatened to falsely claim that your marriage was fake and that you set up you got married to them just for the green card. And say you've applied for VAWA, right? And then you applied for VAWA. This is confidential, so that spouse doesn't know that. But they realize you're not going to comply with them anymore. You're not phased by them, so they say they do call immigration. Immigration now has on record that you've applied for VAWA. So now that you've applied for VAWA, they have to make sure that if they're going to use any information that this person gave against you, it has to be solid evidence they can corroborate. So if this person is saying it's fraud, but they can't confirm that you married them and in a fake marriage, then they cannot use it against you in the VAWA process. The VAWA process is also confidential. It means that you can apply, you can be living in the same house with your spouse who's mistreating you, and they will never know that you applied for VAWA. We use our office mail to be the safe address. So all correspondence comes to us, and then we work with our client in a confidential setting to exchange documents and to exchange, for example, their work permit and all of the different benefits that they get along the way. Most importantly, you do end up with the green card once your application is approved. So my conclusion here is, if your gut is telling you that you can't trust this person based on the way they've treated you, your spouse has mistreated you, um, you need to explore VAWA, and you need to make sure you file for this early on. Don't use it as an alternative. It can be used as an alternative. Don't get me wrong. It can be used as an alternative. Excuse me, I have my puppy with me. It can be used as an alternative, but it's best you not, because then there can be more complex issues that arise if you've experienced a denial, or if now they have on record that somehow your spouse showed that the marriage wasn't real. So you don't want to murky up the water for yourself like that. You want to explore VAWA early. Now, say though you never saw this coming. Say you're going through the marriage-based process, everything was going really good, and then maybe a month before the interview is when you start seeing signs, but things have been good so far, so you really don't want to give up on your spouse. And then it's at the interview, though, that they really come out and start to really show their colors. I mean, there were the red flags, they mistreated you within that month before the interview. But now they're at the interview and they really have shown their true color. So you didn't even really have time to truly consider the VAWA process. Say you go to the interview and the interviewer, they either tell you they want more evidence, or they start to tell you that they don't think the marriage is bona fide because the spouse acted terribly at the interview and did not show that it was a bona fide relationship. What do you do in that situation? So at the point where you're way down in the process, and now they are showing their true colors just shortly before the interview, gives you no time. At that point, you can transfer. So before they deny your application, but this is where it's urgent, because before they deny your adjustment of status application, you need to then consider to whether you want to transfer your case from the I-130 marriage-based process to VAWA process. That is possible, because sometimes you don't see it coming. I do have, for example, a situation where everything was going good in this case, and then they filed the papers, and everything was being processed well, and then boom, the spouse ghosted them. I mean, there were the signs, of course, there are little signs here and there. But when you're in love, when you're seeing a little thing here, a little thing there, a little comment about their immigration status, and they're the only ones that can do it, and they'll go ahead and lie to immigration if they don't comply with them. But it's scattered type of events in the marriage, and then boom, the spouse leaves, ghosts them, and abandons them. In that case, can you do VAWA? Yes, and we've done it for our client, and the case is going very well. It's going very well in the process now that we've transferred it from the marriage-based process to the VAWA process, because it did involve emotional abuse. It involved extreme cruelty, because my client was abandoned by her spouse after, of course, that spouse put them through, put said comments here and there, and was controlling. Then at that point, after the abandonment, it did amount to extreme cruelty at a minimum. So my thing here is, if you have no choice and it comes out of the blue, explore VAWA. Right now, VAWA is not for situations where you were not mistreated and you want to do this on your own. VAWA is for situations where you were emotionally mistreated, financially, physically. Physical abuse is not required. Of course, that does meet the VAWA criteria as well, but it can be other types of mistreatment as well. So, if you do have the choice, you don't trust this spouse because they've already put you through hell, VAWA is the way, right? VAWA is where you need to look. to avoid any further complications. But know that you have an option to transfer it from marriage base to VAWA if suddenly you're in the middle of the process and you realize that things are going south with your spouse. All right. So I think I have covered what I wanted to cover in regards to choosing between continuing with your marriage process or you're going to apply for VAWA. Now, if you are going through this situation, as I said before, don't wait. Click on the link and call the office. So when you click on the link, you'll see buttons. One is to schedule your own appointment. One is to go out to the website, learn more about me as the attorney, the firm, the things we've done for our clients. And then you can go ahead and schedule your own consultation there as well. You can call the office if you want to talk and ask more questions before you book, and they'll be more than happy to assist you. I see here, do you have payment plans? Absolutely. The first investment that you should make is in the consultation, because this is where you're going to get legal advice, you're going to get guidance, and I'm going to be able to evaluate your case at the same time to tell you what the costs are. All right, so let me go through some questions. I see tons of questions. So I am on multiple platforms here. I'm on Instagram, I'm on YouTube, Facebook, and Twitch. I'm also on TikTok. So what I do is I'm going to scroll through each platform to answer your questions. So just bear with me, keep putting those questions in the comments. I'm going to start with Instagram, scroll through, answer some questions there. Then I'm going to go to YouTube and Facebook, answer questions here, and then I'm going to go to TikTok. So bear with me. And as I am answering questions, you'll learn more information, because I'm pretty sure one person is asking a question that many of you want to know about. Is it possible to get a visa for my 2-year-old if I'm a green card holder? So you can get a visa. I mean, your relative, your child can always get a visa. However, that visa is not going to be because you have a green card. If you're talking about them coming to visit on a B1, B2 visa, visitor's visa, then that you have to show that the child has a strong enough connection to the country that they're from, that they will return. And that's going to depend. So, for example, is the child's other parent there? Because you're one parent here. Is the other child's parent there? What are the assets of the parent that's connected to the child? And this is where it may be challenging because they want to see that your child who's 2 is going to remain, just do temporary visits and then go back to the country. Now, you can file for the green card. If you're a green card holder, you can file for your child's green card. Or if you're married to a U.S. citizen, that your 2-year-old is now your U.S. citizen spouse's stepchild. And your U.S. citizen can file a petition for them, and they can go through a faster process while they're outside of the U.S. What if I decided I don't want to live with my husband anymore, but we are still very much together? So that's a personal preference. But if you're going to live apart from your spouse because you just feel like you both get along better that way, then the next question I have for you is, what evidence do you have to show that your marriage is bona fide, right? What are you still doing as a couple? Are the both of you on each other's lease? Are you still paying joint bills together? Do you partake in shared benefits? You're going to have to, if you're going through the process and you're living separately from your spouse because you have a non-traditional marriage, you're going to have to up the game in your evidence. So it can be challenging because many officers do approach such living arrangement with skepticism. So you have to make sure that you up your game. You have to be very convincing in your evidence, because it's going to be challenging. Are there consequences to changing address? Make sure that you update the immigration about changing your address. Make sure you do it early on. You can do that by going to the USCIS and do AR11. That is what will help them to change your address in the system. There will be consequences if you don't change your address, in that you are not going to get, you may get a request for evidence, you may get important correspondence from immigration, and if they don't have your correct address, you won't know about it, and then it could lead to a denial. It could lead, for example, I've seen this happen with people who say they changed their address and the interview notice went to the wrong address. They didn't know that the interview was scheduled, and as a result, they got a denial for their green card. Do you have to be approved first for T status to get a work permit? Yes. My fiance is a green card holder. What is the procedure like? Will the procedure be hard? So if you're outside of the United States, it's a process, right? Any immigration application you're submitting is going to have its challenges, and you have to make sure that you meet the requirements. The way you're going to ensure that you are going through the process smoothly is you want to make sure you're meeting requirements. You want to understand fully what to expect during your process, and don't guess. No guessing, and don't do it by yourself, because I've seen simple cases turn very ugly and complicated because one decided to do it themselves. So now, your fiance is a green card holder. Are you here in the US? If you're here in the US, um, you have to have a current priority date. You have to have current legal status to be able to file for the green card while staying in the US. Right now, you have a wait list. The wait list, right now, they're just processing those applications that were submitted on or before September 1st of 2023. And it can take months for them to move from that date. So, for example, you're here, you have to maintain your legal status for the entire time that you're waiting for your priority date to become current. And that can take months, maybe even up to a year, at the rate they're moving. If your priority date isn't current, then you run out of your status. You'll have to wait for your green card holder spouse to become a US citizen to be able to file while being out of status and stay in the US to get your green card. So be mindful of that. This is where it's very, very important to get legal advice, because it's going to be there. You have to meet very specific requirements. Now, if you're outside of the United States, your green card holder spouse is going to file an I-130 first with all the evidence, of course. When that's approved, then they will send it to the embassy in your country, where they're going to schedule you for the interview. I mean, put very simply, that's the process you look out for, and it takes about 2 years. If a marriage-based petition is returned due to a payment declined, should you redo the forms or just return the ones you received from the USCIS? So if it is rejected, so in this case, it's rejected due to the payment, you don't need to redo the forms. You can just resubmit, correct whatever error or issue a USCIS is having, and return the form. But keep in mind that I am not giving personalized legal advice. This is general information. And so whether that's advisable in your case is going to depend on what's going on. Here, you said it was rejected just because of the payment. So it wouldn't be the forms that would be the issue. Now, sometimes when they return a rejected application, it's all jumbled up. So you just have to make sure put everything back in order and then resend everything with the payment. What if I'm over the age of 21 and my mom is a green card holder? How long would it take to get a work permit and green card? So it's taking 5 to 7 years. The work permit is not going to come unless you qualified for adjustment of status. It may never come in this case. So this is where it's important to understand what you need to do. But it's not going to be a fast solution, and it's not going to be a direct path to the work permit. Actually, if you're out of status, you're 21 or over, and your mom is a green card holder, the work permit is never going to be issued based on this. You're going to have to go through a process where you're going to have to apply for a special waiver to forgive the overstay, and then go back to your country when the interview is scheduled at the embassy and the waiver is approved. Then you'll come back in, all being well, and it's approved at the embassy, come back in as a green card holder. So that's the thing, that's the downside here, is it's not a direct path to the work permit. That's what I'm going through now. So if you're going through something like this, you're not alone, and I help clients just like you. Give us a call. Let first schedule the consultation and let's talk in detail. Is it possible to get a visa? So I answered that. Um, What if you apply for VAWA but your spouse died? So the good news is, I mean, I know this is a terrible situation, and my condolences to you, because I know in some cases, even if your spouse mistreated you, they're still your spouse. So my condolences to you in this situation. But if you've applied for VAWA and the spouse passed away, you have already applied for VAWA, and so it should not affect your eligibility. Where it could affect your eligibility is if you filed for VAWA after the spouse's death. And if you did not apply up to 2 years, within 2 years after the spouse's death, then you would no longer qualify. But in this case, you've applied already, so it doesn't affect anything. And the spouse is not included to begin with. So it's confidential, so they will proceed with processing your application. Good day, my mother filed for me and I get confirmation that documents complete from last October. Now I have uh, to do the interview. Yep. So it's taking about a year and a half to get that interview date. Is it possible to get a visa? So I answered that. How long is the wait period after being approved? Okay, I think this is based on being the spouse of a green card holder. I'm not sure what wait period you're talking about after being approved. I'm not sure. I think if you're talking about VAWA after being approved for VAWA, you're looking at maybe another year to get the green card. Suppose there were no red flags. So whenever you're applying for VAWA, there has to be a red flag and, of course, actions against you at some point. So even though, yeah, you didn't have red flags before, if you experience mistreatment or extreme cruelty, even if before you never experienced any mistreatment, but then wham, suddenly the spouse is doing this to you, you qualify for VAWA. It doesn't affect you. This doesn't have to be going on for months. And all it takes is one time. For example, if a spouse hit another spouse one time, that's abuse. That's abusive. That qualifies you here. Because one time is enough. One time is enough. After doing the biometrics, how long does it take to receive approval for EAD and AP? I don't go by timelines after the biometrics. Biometrics are all over the place. I go by when it was filed. And if it was filed, I'm saying for marriage base, 3 to 6 months. For VAWA, 9 to 8 to 12 months for VAWA. What about changing it from VAWA to marriage base? So that I've never had a situation like that. Um, but Now, if it's marriage to another person, you would just be disqualified from VAWA. You cannot apply for VAWA and then get married while you're applying for VAWA. That will disqualify you from VAWA. What if you applied for VAWA but your husband passed away? Then it shouldn't affect you. All right. Okay, what's the timeline for VAWA? So 2.5 years. How long does I-130 take to be approved? 9 months to 12 months. I recently passed an NY bar, waiting to congratulations. How much do you charge for a consultation and sign as okay, so the consultation is $150. That's where I'm going to ask you very specific questions to see if you qualify. So call the office. The number is 561-408-4889. So 561-405-4889. I'm putting it in the comments. You can call right now. Staff is ready to assist you. So go ahead. I came to the US when I was 17 and my dad is a citizen. I'm 20. I'm now eligible for citizenship. So if you came to the US when you're 17, you came as a permanent resident and now your dad is a citizen. Your dad became a citizen before you turned 18, you could be a citizen already. So this is where it's very important to schedule a consultation. All right, so I'm going to YouTube and Facebook and Twitch now. So thanks so much for your patience as I am trying to get through all the questions here. So just hang tight. TikTok, I'm coming next. So just hang tight for me while I go through these questions. How can I find you on Instagram? I've checked the link tree and it's not working. So Instagram, go to immigration lawyer Sharifa, and you should find me there. So immigration lawyer Sharifa. What if he's still married but separated, not supporting me financially? And he asked me to join him in the US. Let's talk about that situation. Now, if he's still married, but separated, and he convinced you to come to the US, then I need to understand more. It doesn't necessarily sound like a VAWA unless he married you at the same time that he's already married. However, I have represented clients in similar situations if the facts do line up. So, for example, he got you here, maybe put you up somewhere, told you he's going to marry you, and then started to force you to do work for him, work in the household, cook for him, do certain acts for him, then that could possibly be T status. But I need to get some more context here to understand what exactly happened. I want to change my divorce name to my maiden name as my VAWA case is still ongoing. My question is, does it have any impact on the process? No, you just would update immigration. I also want to relocate to another city, but in the same state. Is it okay? I don't know if it would be okay or advisable for you. Depends on what your situation is. Change address, just make sure you update immigration. That's the most important part. My son is married almost 2 years. Don't get a work permit as yet. Did his biometrics June of this year. Ask for more evidence. He's preparing them after 2 years. What's next? So I would have to understand what the situation is. Sometimes if the case goes too long, you could put in a case inquiry, but there's not much I could advise here unless I understand the case fully. I came to the US when I was 17. My dad was a citizen, so I answered that. Is that true that T visa holders cannot go to their country to visit the parents? So yes. So you can't, what happens is you have T status. Whenever you're granted a status in the United States, you're not granted the authority to leave. Once you leave the country, you lose the status. And then there is a requirement of the T status that you show you will face extreme hardship if you go back to your country. So if you leave, you are on T status, now you leave, you go to your country, you don't have status, you don't have authority to re-enter the country again. Then you go to the embassy to try to get your T visa. Now they're asking, how is it you are in the US? You when you are applying for T status, you said you would face extreme hardships if you return to your country, and here you are now at the embassy in your country applying for a T visa after traveling back to your country. And so this raises questions about the credibility of your application and can disqualify you. So, in a nutshell, travel, yes, travel is going to be very restricted. It's not really worth it. Should I continue? Good afternoon. Should I continue with the marriage filing or file for VAWA? I just talked about that. You can rewatch the live and listen to what I had to say, and then see if you can get some insight from that. But I'm here to help. Schedule a consultation. That's the best thing you can do. I have a question. How long will you know if you have an interview for spousal marriage? I-130 when the RFE was only for medical for AOS. So that's a hint. You never know that they could change their minds, but if they're just asking for the medical, that's a big hint that they are looking to waive the interview. How long after T status is filed will I get a response? So usually it can take up to 2 months, depending on how quickly they're processing the receipt notices. So yeah, I would say give it up to 8. If it takes up to 8 weeks, don't panic. F4 waiting 10 years from Pakistan, received welcome letter and updated birth certificate, but processing not open. How long? So for the F4, it's taking, so for Pakistan, I don't believe Pakistan is on the list of countries where it's taking over. So I believe 14 years is the minimum that is taking. So you could be looking at another 4 years. But it depends on your priority date and what's on the chart. So go to the National Visa Bulletin, look at the chart to see what date they're processing. On one other question, if the I-130 is approved, no interview, how long after will I-485 take to be approved? Should not be long. Can you send invitation overseas to a relative to visit the USA with T status? So the invitation is not going to get that person the visa. The officer is concerned about the ties, the strong ties that that person has to their country to get the visa. So the invitation letter is nice, but it gives the officers the reason for the travel, but it's not going to be a determination here. Can I file a case to process faster? So there are, especially on the employment-based immigration, you can pay for premium processing, but that has not extended to family-based or any or humanitarian-based applications. Hopefully in the future, though. I have an immigration problem, but I'd like to speak to you about it. My case was denied. Please send me your number. So I'm going to go ahead and put my number here. And also, if you look in the description of the video on YouTube, Facebook, Twitch, you will see the link to go to be able to get in touch. So look in the comments and you'll be able to see my number. And then, by the way, it's going across the screen. So we have the ticker here on screen and I have the number right there. So you can all look at that number going across the screen. That's my number. Call it and there's staff members that will be available to assist you. And the ticker is going across on YouTube, Facebook, and Twitch. All right, TikTok, thanks so much for waiting while I made my way over to you. I see plenty of questions coming in, so I'm going to go ahead and answer some questions here on TikTok. But it's very valuable for everybody else because I'm reading the questions out so you understand, you learn from this. Where are you located? I'm based in Boca Raton, Florida. However, I represent my clients in all 50 states and around the globe. So no matter where you are, we can help. Just call the number. And I believe the number on TikTok, if you scroll up to the top, you'll see a little bio about me and you'll see the number there as well. Do you do marriage-based green cards? Yes, absolutely, and very good at it. Is there anything I can do to speed up my K-1 visa process? So there's always the ability to ask for expedite requests, but you're going to have to meet their requirements. When can you expect your EAD after biometrics? So the date after it depends on what you're filing for. Marriage-based, you're looking at 3 to 6 months. Other types of applications, like the VAWA, for example, 9 to 12 months. And then the T visa you get after approval. Asylum is 6 months. Employment based, 3 to 6 months. If you cross the border, can you get married to a veteran without seeking asylum? So if you cross the border, it depends on how you cross. If you cross without permission, then you can always get married to a veteran. You'll have to seek parole in place to be able to stay here and apply for your green card through adjustment of status. If you cannot get the parole in place, then you're going to have to go through a different process to be able to get the permanent residence, which does not involve you staying here in the US. So it just depends. I filed for marriage case and they moved my case. Is it a good thing or no? So right now they're trying to shift cases around to improve processing time. So I'd say that's a good thing. They're trying to move things around. I apply as VAWA, got, I'm not sure. I apply as VAWA, got the receipt notice. So I'm waiting for the next step, which is the biometrics notice. With biometrics is your fingerprinting appointment. I came to the US when I was 17. My dad is a citizen now. Okay, I answered this on the other platforms. Thanks for following me on the other platforms. I have a pending asylum. Can I get married to a US citizen, change my status? That is a complex question. Now, you have a pending asylum, but do you have it in court or did you apply for it affirmatively? Did you enter the country legally or did you come across the border? Were you paroled into the country? Because that's going to tell us how exactly you can file for the status here. My family filed I-130 F4 in 2014, got welcome letter. When can we expect processing to open? At least 14 years. Can I work in immigration as a paralegal? So that's another session or something. How long is a waiver I-601 taken to get processed? So you're looking at 1.5 to 2 years. And it depends on how the waiver was filed. If it was filed during adjustment of status, it could be within a year. But if it was filed, say, after consular processing, then you're looking at about another year, 1.5 years. I have a pending asylum. So I answered that. How long does it take to get approved the I-824? So unfortunately, those are taking a while. It should be really simple, but we're looking at 9 to 12 months for those right now. Hi, I've been waiting 2 years and I-601A wait times was 24 months at the time. Now it's 44. How long more? Now each case is different, but yes, processing times are getting longer and longer for the waivers. Now, 44 months does not mean yours is going to take 44 months, but it does put a wrench in, predictability. And also, if you want to submit an inquiry or get the ombudsman involved or even get the senator involved, you'd have to wait for your time to go beyond the 44 months before you can do that. But there now, what one other strategy is to file a mandamus, that is to file a lawsuit to be able to get around the delay. So that may be an option. My family filed I-130, so I answered that. How long USCIS take to respond to my RFE? So I've seen it in as little as 2 weeks, but I've seen it go as long as 4 months. How long USCIS take to respond to RFE? So I answered that, 2 weeks to 4 months. What forms do I need to fill out for a green card marriage? So there are a number of forms, just depending on how you're applying. If you're applying outside of the US, you're going to start with the I-130 petition along with the supportive documents. If you're in the US, you have to file the adjustment of status, the petition, the work permit, the travel document, which I do for my clients, the affidavit of support, and then the I-130A as well. So make sure you have all of that lined up. How long does adjustment of status take for approval? How long does military PIP take? So adjustment of status, once you've properly applied, you could see it in as little as 4 months and maybe a little over a year. Be prepared for a little over a year. A military PIP, so that's parole in place. That's when your spouse is a military member. If you came across the border without permission, then that would be a way to fix the situation so you can adjust status. In that case, you're looking at about 3 to 6 months for that one. All right. All right. Thanks so much for your questions. I see a few more coming in here, so I'm going to answer those. Since I didn't get to do my live yesterday, I'm going to answer a few more questions and then head out. Does VAWA apply to someone with an I-485 denied based on false claims of U.S. citizenship, or can they renew the 1 year work permit? So your case is complex. You need to make sure you schedule a consultation. There are waivers available, but false claim to U.S. citizenship, there may be some exceptions, but no waivers. So we need to figure out what happened there, whether there is a way to get around the false claims to U.S. citizenship, because that is a serious charge. And tip of the day, don't ever on any of your documents, don't ever put that you're a U.S. citizen. I don't care how, and I know it sounds like I can't relate to what you're going through now, but you're undocumented, you're desperate for work, and you decide you're going to go ahead and put that you're a US citizen on the paperwork so that you can get the job because you desperately need to support yourself. I say don't do it. It's not worth it, because a few years from now, you're going to have an option. You're going to have an option to change your status and finally get that legal status you need. And then they pull up your records and they see that in the past you completed an I-9 document and you put US citizen. That is going to kill your dream right away. There's no waiver for this. In some cases, if you thought you truly thought you were a citizen because you were maybe brought here as a child, so you put citizen, then maybe you have a way out of this. If you were applying for asylum, Maybe you have a way out of this, but there's no waiver otherwise, so it's not worth it. Um, So even if a person got green card from T visa, they cannot travel to the country. Now, with the green card, you're able to travel because now you're a permanent resident. But keep in mind that as a green card holder, if your travel to your country raises any questions about the validity of your T visa application, it could still become back to bite you in the butt. They could open up an investigation to re-review whether you should have gotten the T visa in the first place, and then in turn move to take away that green card. Remember, the green card isn't necessarily a right, it's a privilege. And if they feel like there was something that was in your background that wasn't truthful or raises questions, then they can turn back to take away that green card. So you have to be mindful of the risk associated with traveling on the green card. So my status doesn't matter. I can send that they show their financial ties in their country. So your status doesn't matter because the letter wouldn't really have much weight. The focus should be, do they have strong ties to their country? How long does it take for the work permit after you file asylum? So you should see it after the 180th day, as long as you've applied for the work permit. Can I travel to my country after I get my green card through the T status? So I just answered this question. There are questions. It may raise questions if you in your T status application, raised issues about possible persecution, possibly being targeted in your country, and then as soon as you get the green card through the T status, you're off to go visit your country, then it doesn't stop. Remember, immigration always can go back. They can look at your file and they can decide whether your trip directly contradicted what you stated in your application. And so that is where it's very important to consider the risk. It's not that you can't travel with a green card, but these are the risks that you have to keep in mind. You probably have to show maybe evidence that your circumstances have changed in your country to allow you to be able to travel there. The extreme hardships now have been removed. It's not a sure thing that you travel on your green card to your country, you're going to lose your green card. It's just that it can raise questions and it can open the door for possible complications in the future, especially, for example, you're applying for citizenship. If you're applying for citizenship and it's on the record that you've traveled, because they do have to take your travel history, then they're going to want to understand how is it you couldn't travel to your country before, but now as soon as you got the green card, you could. So every T status, most applications, you have to do the biometric. So yes, with T status, the next step after you getting the receipt notice is the biometrics. That's a fingerprinting appointment, and that can come 2 months. Usually, I see around 2 months after, but I've been seeing them getting longer and longer in the past few months. Can a VAWA application be approved without providing a copy of my spouse's SSN or passport? So usually proof of the spouse's status as a citizen is required. However, what we do is if our client doesn't have access to the spouse's paperwork, then we ask immigration to verify their status. All right, so that's going to be it for me, everyone. Thanks so much for your time and your questions. I'm going to be back on Monday to answer some more questions and then also to come with a topic that will be of interest to you. So thanks so much. Now, schedule that appointment. That's the best thing you can do. My schedule is filling up. It's not going to get any better, so don't delay. Call and schedule the appointment, right? Schedule your appointment so we can talk about your situation and specific solutions for you. Because remember, the information here is general information, it's not personalized legal advice. So you want to make sure that you get that. Invest in yourself, invest in a process that can work for you. Thanks. Have a great day, everyone. See you on Monday. Bye bye.